This webinar, Supreme Court Strikes Down Taxation on Undistributed Trust Income, What Does It Mean?, was a live webinar that was originally produced on Tuesday, July 9th, 2019. It was hosted by David Warren of Bridgeford Trust Company, and he was joined by Bill Lipkind of Wilson Elser and Terry Prendergast of Davenport Evans. Consistent with Bridgeford Trust Company's commitment to provide various means of insights to keep you updated on developments regarding modern trust law, this webinar discusses the Kaestner case and the importance of selecting proper trust jurisdiction in the planning process. We hope you enjoy this recap, and please visit us online at bridgefordtrust.com for more information.
Thank you all for joining us today for a very exciting and extremely timely webinar we put together for you on the recent Supreme Court decision. The Kaestner case has generated a tremendous amount of attention and enthusiasm, frankly, for those of us who have been watching this for years and who are deeply involved with state tax planning issues. So what we put together today is a webinar to look at this trust, or rather this case, and to talk about its practical implications. My name is David Warren. I'm chairman of the board and co-founder of Bridgeford Trust Company, and have been very excited about these issues and issues around selecting proper trust jurisdictions since the launch of Bridgeford in 2012. And I am absolutely thrilled to introduce our two main speakers today. Bill Lipkind, who in many ways is a name that does not need to be talked about in too much detail. He's a very prolific writer. He has always been focusing on these issues, tax planning, for most of his career. And he's really considered an expert in the tax planning space. For those of you who follow this topic, Bill is an absolute expert in the ING strategy, has written multiple articles and has done that strategy very successfully all over the country. And he's taken 40 to 50 clients all the way through the PLR process, having obtained at least 200 PLRs from the IRS. And what's most interesting, I think, about Bill and what he's done over the years is that despite all of the creative and clever tax planning, particularly state tax planning, there has not been a single instance where Bill's issues that he's worked on for clients have been audited by any state tax authority. So not only is Bill extremely creative and an excellent attorney, he's also successful in making sure his clients stay out of trouble. Also with us, I'm very happy to announce Terry Prendergast, an important friend of Bridgeford Trust Company. He helped us get our charter years ago, and he has been doing this work for over 40 years and also is a name that is known all over the country and frankly around the world. Terry works with trust companies, he works with attorneys, he works with accountants, bringing trusts into South Dakota. He's very familiar with these tax planning strategies, having focused on making sure the South Dakota laws can support it. Terry was on the governor's task force, so many of the rules and regulations and laws coming out of South Dakota, you will see, or you should know, that Terry had a hand in writing, including the community property trust statute, which actually he worked on with Bill Lipkind. We're thrilled to have them both talk about their perceptions of this case. It's a very important case. And if you want to hear more from Terry and Bill, you can go to our podcast section at Bridgeford Trust Company. They both have been recently interviewed. Because you have three lawyers presenting this, of course, there has to be a disclaimer, which means that you essentially can't rely on anything that we're saying. Of course, I'm joking, but there is a disclaimer there, making sure that we're clear on what we're attempting to do today, which is to talk about some very, very important issues and to give some practical perspective on what we see happening in the industry. This quote is very important, has been important to Bridgeford, is important to how we've launched Bridgeford, but I think it's so germane now and even more germane as I talk today than it maybe it was before the decision came out. The choice of a state in which to establish a trust is as critical as the decision to create one. I think the Kaestner case and the other conversation we're going to have today is going to make that point. Just by selecting the proper trust jurisdiction and do proper planning, we can accomplish a lot. And in this case, we're going to talk about potentially avoiding some state taxation issues. The Kaestner case is a huge case. Some say it's the biggest tax case coming out of the Supreme Court in decades. And we're going to be real practical in the way we talk about it. What does it mean? What relevance is there relative to the Fielding case, which was denied cert? And the goal here by the end of the presentation is to really leave you all with some practical practice tips and some ways that you can really apply this in every aspect of your conversations with clients, because again, this is one of the biggest tax issues coming out of the Supreme Court in years. And very quickly, just want to set the stage. I know most people on the webinar today certainly understand the issues that we're talking about, but this idea of taxing undistributed income has been a hot topic for many years. And in most states, as we know, the trusts are taxed, or the income inside of trusts have been taxed. And a handful of states, like South Dakota, do not have a state income tax. So sophisticated planners like Bill and Terry and others have found ways to deal with the idea of how to avoid state income tax. And that really gets to the heart of what we're talking about today. So before we go further, for those of you who are getting CPE credit for this webinar, and welcome, we have to do various polling questions. And Terry and Bill thought these were test questions for them, and they're not. They're for people who are listening. So no pressure, Terry and Bill, to have to answer these questions. But I will read, what is undistributed trust income? And A is income distributed to a beneficiary. B, income retained in trust, and C, income paid to the IRS. So again, for those of you who are doing this as a CPE credit, you have some time now to answer the question. I think all of us are excited to see how many of you get it correct. So we have to pause a bit to get that. But as we're waiting for the results to come in, back to the conversation in terms of the idea of undistributed income. There have been a handful of states across the country that have looked at this issue from a tax perspective and really have generated case law very consistent across the board. New Jersey, Pennsylvania, North Carolina, of course, which is the focus of today's conversation, Minnesota, and others, where they've looked at this issue from a constitutionality perspective and have kind of come to a similar conclusion. And I'll let Bill and Terry sort of talk more to that and what impact that has on today. So I think we're going to go forward with the polling answers, which are, well, okay, 98% of you got it incorrect. I'm joking. 98% of you got it correct. The answer, of course, is income retained in a trust. Excellent. And so we can move forward now. All right, so sort of wrapping up the conversation around what are we talking about today? The resident trust is a trust established by a resident of a particular state. Source versus non-sourced individual, rather undistributed income is important, and that's something we'll distinguish as we go forward, particularly under the cases. And as I mentioned, there's a trend in this case law, which again has become very exciting, has been exciting for Bridgeford and the worker and the planners that we work with. And one more polling question before we move forward, which is, what is a writ of certiorari? A, the beginning of a civil lawsuit. B, a Latin desert. Or C, a request to the Supreme Court to hear a case. So as we're waiting for the answers.
Well, we all know the answer, David. It's the Latin dessert.
Yes, which is my favorite, Bill. You're exactly right. You're exactly right. As I had mentioned, as we have gotten involved with these issues, the idea of modern trust law drives so much of these conversations. And so we're very happy to be part of the discussion today. And the goal, again, is to end with some practical pointers, practice tips, and really kind of analyze what this case means for all of us. And how do we advise clients going forward? So I think we're close to getting our results. And here they are. Nobody picked Latin dessert, Bill. I don't know if that surprises you. Of course, the answer is C, a request to the Supreme Court to hear a case, which brings us right into the most important aspect of our presentation today. Of course, in January 2019, writ of certiorari was granted. And that opened the door to, again, confirmation and affirmation of so much of the very sophisticated tax plan that we've all been involved in. South Dakota, recognizing the importance of this case, took the lead. And Terry, if you don't mind, could you please explain to us really what really happened with respect to the ability to get involved and to have an impact on the court's decision here?
Yeah, thank you, David, and thank you, listeners. Kaestner really drew great interest from trust and estate practitioners when the Supreme Court granted cert. Everybody was surprised because it was the first case concerning the constitutionality of state income taxation at trusts that was accepted by the U.S. Supreme Court in over 60 years. A lot of people had speculated that the court was going to abandon some of its long-held principles of state and federal taxation law and allow expanded taxation, since just last year the Supreme Court had upheld against a Commerce Clause challenge in the Wayfair case the sales taxation of online merchants who did not have a physical presence in the state imposing the tax. People were wondering if the court was now going to revise long-standing due process principles regarding constitutionality of state taxes. Those principles, those due process principles, have consistently held, and since Bill and I were in law school and before that, that a state tax must be considered under both the commerce and due process clauses, and it must be constitutional under both. But the grant of certiorari in Kaestner was only to consider the case under the due process clause. North Carolina's taxes said that they applied on undistributed trust income with one qualifier, that being the North Carolina residence of the beneficiary. So a number of amicus lined up to support North Carolina or to support the trust. 3 briefs were filed supporting North Carolina, including a brief filed by the state of Minnesota, which a number of other states joined, and that kind of is significant because of the Fielding case, which we'll talk about a little bit later. The state of South Dakota and 3 other states filed a brief urging the court to affirm and hold the North Carolina tax unconstitutional, and they cited significant differences between the sales tax considered in Wayfair, which was a sales tax imposed by South Dakota and was determined constitutional, and the beneficiary residence income tax in Kaestner. And the South Dakota Trust Association, as David mentioned, led an effort and was joined with the New Hampshire Trust Council, the Estate and Trust section of the Delaware Bar, the Nevada Trust Company Association, and the Tennessee Bankers Association, filed a brief in support of the taxpayer. There were 10 amicus briefs in support of the taxpayer opposing the tax, and many practitioners were concerned that the traditional notions of a trust could be skewed by the North Carolina reasoning. So an effort was made to be sure that the court recognized and reaffirmed the legal relationship theory of a trust and recognized that the trustee was the legal owner of trust assets. So if we can go to the next slide, the key facts in Kaestner actually are quite simple. North Carolina imposed a tax on any trust income for the benefit of a North Carolina resident, which was interpreted to mean any beneficiary residing in the state of North Carolina, whether they received income or not. The trust in question was created by a New York resident, Joseph Rice, in 1992, and he had a New York trustee. He later divided it into 3 separate share trusts that were all administered under that 1992 trust agreement. And one of the trusts was for his daughter Kimberly as primary beneficiary, with her children and her siblings as contingent remainder beneficiaries. Though her siblings never lived in North Carolina, Kimberly moved to North Carolina in 1997. By 2005, none of the contingent remainder beneficiaries lived in North Carolina, only Kimberly. Interestingly, Kimberly has also since moved from North Carolina. I don't know whether the imposition of $1.3 million of taxes had something to do with that, but anyway, the tax years in question were 2005 to 2008, and during those tax years, Kimberly resided in North Carolina but received no income from the trust. And the reason for that is the trust gave the trustee absolute discretion to distribute to the beneficiaries, and no distributions had been made. The trust originally was to terminate in 2009 when Kimberly reached 40 years of age, but using New York decanting law, the trust was decanted in 2009 which of course was after the tax years in questions, to a new trust. So instead of terminating it, it was decanted. North Carolina imposed a tax for the 2005 to 2008 years of about $1.3 million, which the trust paid under protest and sued for a refund. 3 courts in North Carolina, the trial court, the Court of Appeals, and the North Carolina Supreme Court, held the imposition of the North Carolina tax based solely on Kimberly's residence in North Carolina was unconstitutional. The trial court actually held it unconstitutional under both the Commerce Clause and the Due Process Clauses, but the appellate courts only addressed the Due Process Clause. That's why the Supreme Court granted cert. And the grant, as I said that it was to decide whether the Due Process Clause prohibits states from taxing trusts based only on the in-state residency of the trust beneficiaries. So we can go to the next slide. The key fact in Kaestner was the residence of the in-state beneficiary. But because this was an as-applied analysis, in other words, the Supreme Court looked at the tax as applied to this specific case, the opinion expands upon other facts as well. Normally, traditional due process that we all learned in law school, there's 2 issues, both of which must be answered in the affirmative for a state's imposition of tax to conform to the Due Process Clause. First, is there a minimum connection between a state and the person, property, or transaction sought to be taxed? And second, is there a rational connection between the income sought to be taxed with the values connected to the state imposing the tax? The Kaestner court didn't even have to reach this prong because it decided it based on the first prong. But to determine that first prong and the minimum connection, the court majority looked at a number of facts, including the following ones. The trustee and the administration of the trust all occurred outside North Carolina. The trustee was located outside North Carolina. There were no direct investments of trust property in North Carolina. The settlor didn't reside in North Carolina. The North Carolina beneficiary did not receive distributions. The North Carolina beneficiary had no right to demand distributions and no right to make investment decisions. And the trust agreement, as most of our trust agreements do, had a spendthrift clause which prohibited alienation or assignment of any income. And the beneficiary during the years in question could not count on absolutely receiving income in the future. So the court's holding, Justice Sotomayor ruled for a unanimous court that they wanted to reaffirm the principles of 2 90-year-old cases. One was Safe Deposit and Trust Company, and the second was Brooke. And those cases said that the in-state beneficiary must have a right to control, possess, enjoy, or receive trust income before the state can constitutionally tax such income. Justice Alito's concurring opinion affirmed that these 3 cases, or these 2 cases, are still good law, and the majority didn't even need to go beyond them. To Justice Alito, the question was clear, that in the case of taxation of trust assets or income from intangible assets held by a trust, does the resident of the state that wants to impose the tax have control, possession, or enjoyment of the assets? Because in Kaestner the answer was no, North Carolina could not tax the trust or the trustee on the intangible assets. Now, North Carolina made a few other interesting arguments that the majority addressed. First, they urged that the trust and beneficiary were so intertwined that if you could tax any of the 3 constituents, you could tax the trust. Well, thankfully, the Supreme Court refused to make that leap in logic, and they kept clear that the various constituents of the trust, the grantor, the trustee, and the beneficiary, were not to be all bundled together. And that's always been our practitioners' general understanding of trust structures. Second, North Carolina said, well, if you turn down our tax, all other state income taxes on trusts will fall. And of course, the court made clear that it was making a specific holding as to the Kaestner Trust and North Carolina's statute, and that other state income tax cases would be handled as they have in the past, with the courts determining constitutionality based on the principle stated. And finally, North Carolina made an interesting argument that said that, well, taxpayers and their lawyers will game the system. And the court stated, first of all, this wasn't proven, and that secondly, a settlor basically had to make a trade-off decision. If you want to give control, possession, and enjoyment of assets in the future to a beneficiary, you may be taxed by the state of the beneficiary's residence. But if you want to remove that control and give it to a trustee, as was done here, you get a state tax benefit, and the state of the beneficiary's residence cannot tax that trust. So basically, the taxpayers were overjoyed with the Kaestner decision. But because it only dealt with such a narrow state of facts, our question is it significant, and what guidance can be gleaned? And around this same time, one of the state Supreme Court cases that declared Minnesota's state tax statute unconstitutional as it was applied to worldwide income of an out-of-state trust, a case called Fielding versus Bowerly, also appeared through a petition for cert to the United States Supreme Court. In Fielding, the Minnesota Supreme Court held that the grantor residence rule as applied to trusts which held tenuous connections with Minnesota could not support the taxation of the worldwide income of the trust, and under the due process analysis, the taxation as applied to the Fielding Trust failed both of those due process tests, both the minimum contacts prong and the rational relationship prong. Facts in Fielding were that the Minnesota grantor had established grantor trusts, but in 2011 he released the power to substitute assets and the trusts became irrevocable. And under Minnesota's resident trust statutes, Minnesota could tax all their income since they became irrevocable at the time that Fielding was a resident of the state of Minnesota. So this was a grantor residence statute. The trusts did have a non-resident trustee. The trust had 4 beneficiaries, only one of which resided in Minnesota. And of course, all beneficiaries were discretionary, as in Kaestner. The trust held stock in a Minnesota sub-S corporation and reported their pro rata share of the income attributable to Minnesota as taxable to the state. But what happened was in 2014, the trustee sold that stock and he invested the proceeds with a California-based investment manager. So from that time on, the trust held intangible assets held in California outside the state of Minnesota. Minnesota then sought to tax the worldwide income of the trusts, not just the Minnesota source income. Again, the taxpayer paid the tax under protest and sought a refund for the difference above the Minnesota source income. So both the Minnesota Tax Court and the Minnesota Supreme Court on appeal held that the application of the tax to the worldwide income from the trust violated the due process clause and was unconstitutional as applied. Again, the Minnesota court in Fielding, as the Kaestner court before, looked to an as-applied analysis to the facts and circumstances and found that even though a Minnesota attorney drafted the trust, there was this ownership of stock interest in a Minnesota corporation. Minnesota law was the choice of law in the trust, and despite the Minnesota residence of one of the 4 trust beneficiaries, those contacts were too tenuous to meet the minimum contacts provision in the first prong of due process, and also those contacts bore no rational relationship to the overall worldwide income of the trust. So the Minnesota court declared the Minnesota resident trust tax as applied to these trusts unconstitutional. But interestingly enough, the Fielding Court cited favorably the safe deposit case, the same 90-year-old case cited in Kaestner by the majority in concurrence in Kaestner, and indicated that the grantor's connections were irrelevant to the trust's income, since the grantor could not possess or control the income. And further, the Fielding case cited safe deposit for declaring that ownership of the intangible property, the stock in the Minnesota Sub-S Corporation, does not follow either the grantor or the beneficiaries, and thus could not establish the necessary rational connection under due process to tax the worldwide income of the trust. And finally, Fielding also stands for the proposition that contacts prior to the tax years in question are not relevant to the imposition of the trust. Well, a week after deciding Kaestner, the U.S. Supreme Court denied the cert petition in Fielding. Now, what does that mean? We've long learned from Justice Frankfurter, and we learned in day one of law school probably, that a denial of cert means only that at least 4 justices did not want to grant cert. The Supreme Court decided not to decide, as it does in 99% of the cases filed before it. So the cases will all tell you that a denial of cert is not an expression of opinion on the merits of the case. But this Fielding case denial had a unique procedural posture. And as Justice Robert Jackson said a number of years ago, he was the justice of the Supreme Court that also presided over the Nuremberg trials. He said, "It is just one of the facts of life that every lower court does attach importance to denials and to the presence or absence of dissent from denials, as judicial opinions and lawyers' arguments show. So as one of those facts of life, and since Kaestner is the first time in 60 years that the U.S. Supreme Court has written an opinion on a state taxation of trust case, it's interesting to examine specifically the timing of Kaestner and Fielding as they were before the court. As I mentioned, both Kaestner and Fielding were decisions of the Supreme Courts of the state in question, North Carolina and Kaestner and Minnesota and Fielding, and both held unconstitutional under the Due Process Clause their state taxing statutes on trusts with out-of-state trustees and administered out-of-state. Kaestner reached the Supreme Court first with a petition in early October of last year. And after conference, the justices requested a reply from the trust. 15 days later, the state of Minnesota and Fielding filed its petition. After the Kaestner court considered the petition and responses, it granted certiorari on January 11th, 2019. And following this grant, Minnesota specifically requested that Fielding be consolidated with Kaestner for argument under the Supreme Court rules. But the court didn't grant that petition. Instead, the court set Kaestner only for argument on April 16th. And it first considered that Fielding petition on February 22nd, 2019, but held off making any type of decision. But after the Kaestner opinion on June 21st, 2019, affirming that North Carolina's beneficiary tax was unconstitutional, the Supreme Court relisted the Fielding petition for its June 26th conference, and then it denied cert review on June 27th, 2019, which had the effect of letting the Minnesota determination that Minnesota's resident settlor tax on an out-of-state trust was unconstitutional stand as the law of that case. So given this timing history, although the Kaestner opinion was narrowly drawn as to North Carolina's tax, the timing of Fielding may indicate that the cert denial is also important, notwithstanding the caveats that a cert denial is said to be meaningless. Both cases affirmed determinations under the Due Process Clause that state taxes on trust income were unconstitutional, lest the link to, where the link to the taxation, the beneficiary residence or the grantor's residence, had no control or possession of income sought to be taxed. Both cases cited that 90-year-old case of safe deposit, which Justice Alito's concurrence in Kaestner says is not open to reconsider. The question is there control, possession of the asset or enjoyment of the asset by the party to the trust relationship located within the state? And both cases teach us practical lessons that I believe Bill is going to now address.
Terry, thank you very much. That was excellent. And to understand the holdings and the facts of these cases is vitally important. And you're right, Bill's going to go into the question of what we know from these cases and what we don't know from these cases, and really kind of trail into the lessons going forward for practitioners and those of us who are so passionate about state tax planning. So Bill, please.
Okay, thank you. That was a great job, Terry, and thank you, David. We have, I'm going to talk to you in a practical, hopefully from a practical point of view, having been exposed to many of the states in the union and their taxation. You really have four different players. You have the beneficiaries, you have the grantor, you have the trustee, and you have the assets. And it's how those things meld together that can either support or undercut the ability of a state to tax. Clearly, this is like the emperor in the new suit of clothes. The mere fact that a beneficiary of a discretionary trust happens to live in a given state isn't going to let the state tax. There's an implication, although not a statement, that you could say the same thing about the settlor, because indeed, putting aside the settlor also being a beneficiary, the settlor transfers his assets into a trust, and then it's out of his control. So I would think that the logic of Kaestner would apply where the only contact was with the fact of the settlor, and the settlor had no further role. Certainly Fielding would agree with that. Perhaps the state of Connecticut would not, but then they have some beneficiaries thrown in. The importance of the safe deposit case really gets into the fact that when you separate out the focus on the beneficiary, where he's located, and the domicile of the grantor, you still need, even if some rational connection between the assets that a state wants to tax and the assets that are in the trust. And we're going to get into that in a few moments. So we clearly know that a naked beneficiary and probably a naked settlor is not enough. Next slide. The other extreme is that, without doubt, there is no question but that if the trustee is domiciled in a given state and administers the assets out of that state, and the evidence of ownership of the assets are all in that state, then that particular state is going to be able to tax undistributed trust income. Indeed, the location of the trustee is one of the exceptions in New York, New Jersey. I mean, Arizona uses it as a standalone. So we have these two extremes. And the word up there is administration. And President Clinton taught us that all depends on how you define administration. It's not a clear-cut, bright line, self-evident situation. David, next. Let me talk through with you some of the ambiguities that exist, and whether you're putting together a non-grantor trust for a client, or you're reviewing an existing situation, wondering whether you should seek a refund from a state that wants to tax you. These ambiguities are going to enter into the equation. I'm going to just assume, for the sake of David, that the trust is in South Dakota, that the trustee is in South Dakota, it's Bridgeford, and let's just assume that the settlor is coming from California or New York or some other, or Illinois or some other high tax jurisdiction, or Minnesota. What about real estate directly owned by the trust, assuming that some trustee will take title to a parcel of real estate, notwithstanding environmental issues? Now you have something where the state has something to be concerned about. If you couple that with the grantor is there or a beneficiary is there, where does that get you? What if there is a substantial, what if there's any source income coming from the state? Client puts into the trust ownership interest in a pass-through entity, limited liability company, or a partnership, and we're talking about the domicile state here. This is true in New York and New Jersey. I'm going to come back to that when we get to the next slide. That creates clearly a nexus of some sort between the trust and the state. The courts talk about indicia of ownership other than the real estate. I don't know. It's been a while since I've seen stock certificates. I suppose one could leave stock certificates lying around the wrong state. What's the governing law of the trust? If I'm in New Jersey, do I want to make New Jersey the governing law of the trust and then hire Bridgeford in South Dakota to be the trustee? Hopefully the answer is no. If you have an existing trust and you want to do something to either cut down or eliminate the state taxation, you're going to want to decant it so that the governing law of the trust is not the state that would tax. What do you do with the fact that the trustee is making marketing efforts, comes into the state and conducts meetings with people? Does that give some sort of a nexus? If there's a nexus for service of process, does that somehow slide up onto a nexus for taxing the trust? What do you do when the trustee has his quarterly meeting in the settlor's estate or the domiciliary or beneficiary's estate? It gets very confusing. I have there a reference to restatement of conflicts. Second, what neither Fielding nor Kaestner dealt with is the settlor being a beneficiary of his own trust. Whether one says that's a self-settled spendthrift, or argues it is not because it requires the consent of an adverse party and therefore shouldn't be considered a self-centered, a self-settled spendthrift. We know for a fact that states like New York, New Jersey, Connecticut, California, Illinois, Florida, all detest self-settled spendthrift trusts. I withdraw Connecticut. They're changing their law. And that means that there's a basis under restatement of conflicts to say that we can disregard the settlor's selection of South Dakota as the applicable state and the applicable law. Well, what does that do to state taxation? And is there a difference between an incomplete gift trust and a completed gift trust? Well, to have an incomplete gift non-grantor trust, as we all know, the settlor is going to retain certain powers over disposition of assets, both during his lifetime or her lifetime and upon death. The does that retention, is that enough to give the settler's domicile state to say this isn't a mere domicile of the settler in the state? There are these other retained powers and we can tax. This type of an ambiguity raises the question of what do we do? Next slide.
Yeah, Bill, I think that this is a great place to pause. I mean, from my perspective, this is probably the most important aspect of what you're going to talk about, because I've read lots of different articles and interpretations of mostly Kaestner. Often people have kind of ignored the fielding impact on things, but going through these I think is important. So thanks for taking the time here.
So if we think about the efforts we make so that the selection of the applicable state is respected by the settler's domicile state, we should know, we want to maximize the contacts with the state for the trust situs. So that if you have a directed trust, for example, and you have not only the administrative trustee and maybe a distribution trustee with Bridgeford, but you have a separate investment trustee, you really want to have the investment trustee be in South Dakota also, if that's your applicable state. Now, fortunately, South Dakota has a very cute low level of work statute for creating an LLC that is slightly regulated but allowed to serve as a fiduciary other than as an administrative trustee. So what we'll do is we'll say, for example, if I'm setting up a trust from New Jersey and I want my New York wealth advisor to be running the money, I'll have my New York wealth advisor establish a South Dakota LLC to be the investment trustee and let him own it. You want to maximize the connections with the situs state and minimize the connections with the domicile state. And it's also true for the beneficiary state also. If there's real estate involved, you're going to wrap that in an entity which is not good, which ideally, again, using South Dakota as our example, would be a South Dakota entity, not in my home state or Delaware. If I have a pot full of cash and marketable securities, we're going to wrap that in a limited liability company to be owned by my trust. So that too, that ownership is an intangible domiciled in my trust situs state, not having the direct ownership. The trust should be wholly discretionary, that the beneficiaries and the settler have no particular right of receiving anything is obviously, with Kaestner in mind, a good thing. We restrict the role of the protector. There was an advisory opinion by New York many years ago, which is cited by a lot of states, to say that where people who are not trustees are given discretion over things that are normally done by trustees, that can make them into a trust fiduciary. So that if I have a committee of investment advisors, if I have a committee of distribution advisors, it creates that type of ambiguity. If I let a protector start to add and subtract beneficiaries, if I let a protector modify trusts, if I start to create a question, is the protector a fiduciary? Now, if the protector is domiciled in South Dakota, I sort of don't care. But if the protector is not domiciled in South Dakota, then I will restrict the protector to doing that which the settler could do, namely retain the right to hire and fire the trustee. So one has to be sensitive to the role of the protector in drafting. We talk about never using the settlor's state law to be the applicable law of the trust, but we go further. We put into our trust documents now not only, again, using South Dakota as the example, that South Dakota law prevails, but we say any dispute by the settlor or a beneficiary with the trustee has to be brought exclusively in the courts of South Dakota. We don't want the settlor's domicile state to have any right to protect the settlor from anything South Dakota trustee is doing, and similarly for the beneficiaries. This is not only good for maximizing contacts with South Dakota for choice of law, it's also good for minimizing the ability of a domicile state of the settlor or beneficiary for asserting that they're doing anything designed to protect the beneficiaries. Let me talk for a bit about certain position taken by New York. And I might not be talking about it, but for the fact of what New Jersey did. And therefore, I think that you all just have to be sensitive that others could do the same. New York passed a statute that says if there's any source income from New York, this is for a New York resident trust, that is a trust established by a New York resident. If there's any source income, then we can tax all accumulated income. So you say to the tax people in New York, contemplate $1 billion trust with 1 penny of source income and 999 million, etc., dollars of non-source income. Does that mean you tax everything? And they say, yep, that's what we're going to do. Now, the audience here is going to say, they can't do that, because going to Terry's second prong of due process, there isn't a rational connection between the amount of income of the trust that has a nexus with New York and all of the other income which does not. I mean, contemplate everything else is coming out of intangibles, stocks, bonds, LLCs, where there's no source whatsoever. What do you do about that? I mentioned New Jersey because New Jersey put the exact same provision into their instructions for filing fiduciary returns. And you call up the New Jersey tax people and they say, how did you do that? And you'll find out they quickly send it up to a supervisor. They say, well, we put it into our instructions. I said, wait a second. What is your legislative authority for doing that? It's in our instructions. So if it's in your instructions, that means it's taxable? Absolutely. Okay. New York, I think the New York statute's unconstitutional. I don't like to encourage my clients that they're buying in 10 years worth of litigation, although if for the amount of money that Kaestner had at stake, I'm sure they'd be willing to do it. And I think the New Jersey statute's unconstitutional. And we have workarounds for these things, and we don't have the time to get into the weeds here on the workaround, but what we like to do is see to it that anything that has source income, putting aside subchapter S corporations, we'll just distribute all the source income one way and get a D&I deduction for the trust, and distribute all the non-source income another way, so that the trust that has source income has no income at all. You'll see that subchapter S corporations in your trust are more difficult because of the Internal Revenue Code saying that you got to calculate all of your taxation if you do an ESBT election at the trust level, and you get no D&I deduction. And I have a workaround for that one also, but the important thing is you try to submit, do trust returns that show no source income. These issues in maximizing the contacts with its trust situs state and minimizing the remaining contacts with the settler's domicile state and the beneficiary states, as I've said, go to the essence of minimizing exposure to state taxation where it is and where it's going. I don't think any state is going to rush off and change their statutes based upon Kaestner and the denial of cert and fielding. Whether state auditors want to take positions similar to the New Jersey position is something different. You always want to draft your documents so there are as few talking points available to a state auditor as possible. Talking points cost money and tension, so you want to minimize the talking points. Some people will leave the settlor out as a beneficiary altogether and leave it to a form of decanting or an exercise of a power of appointment by beneficiaries for anything to come back to the settlor to avoid that as an issue. All that having been said, I think I turn it back to David with his polling questions and a discussion of his concluding discussions.
Thank you. Excellent, Bill. I think it's an excellent practical conversation. Terry as well. Excellent discussion. Our final and our last and final polling question is: which state is considered a top-tier trust jurisdiction? A, Pennsylvania, B, California, or C, South Dakota? I think I know my answer, but I'm not allowed to answer. Bill and Terry, you guys are certainly willing to. Well, you'll comment on that in the next section.
I'll jump in on that one. It's a polling question. For all the trusts that we've done, the vast bulk are either out of South Dakota or Nevada. There are differences, minor differences compared to the other states. California's easy at 13.4% non-deductible at the federal basis. What does one have to? My goodness, somebody said California, and whoever said California, the next question I have for them, and does that mean you avoid joint living trust for your California clients so you have the pleasure of probate under California's laws? That was a rhetorical question with only a slight twist to it.
That's a great comment. I mean, I think there's no question that, based on our conversation today and really the way we've looked at this for years, jurisdiction really does matter. And thank you for commenting on what your thoughts are in terms of what have become sort of top tier trust jurisdictions. At Bridgeford, of course, we're very passionate about looking at those from an objective perspective. The reality is all top tier trust jurisdictions mentioned do not have a state income tax, so it's certainly favorable. But as they say, the devil's always in the details, and the nuances are vitally important. And there are aspects about modern trust law that are important to look at. And so we pay very close attention to the details and what can be done in these jurisdictions. And I agree, it seems to be South Dakota and Nevada that are talked about the most. Terry, as a South Dakota attorney, I have an idea of what your opinion would be on this issue, but I have to give you an opportunity to comment, of course.
Well, all that I was going to comment, David, was that you can see when I mentioned about the amicus brief that the South Dakota Trust Association filed to support the taxpayer in Kaestner, which ended up being successful. I mentioned that Delaware and Nevada also joined in with us and their trust associations on that brief, and so we were very happy with the Kaestner decision. And the big thing that I think all the trust associations are happy about is that it reconfirmed the long-held principles of trust jurisdiction and the principles that there are three constituent parts of this relationship, and they weren't going to do what North Carolina wanted and say that if any one part of that relationship is in your state, you're subject to tax.
Mm-hmm. Well, there's no question how important this issue has become by virtue of the hundreds of people that have signed up for this webinar today and all the conversation around it across the country. From our perspective, we're delighted to see some confirmation, affirmation, and even a little more guidance around these issues. We have some questions that we'd like to go to, and I think I'll take one that came in earlier. And the question essentially asks of you both, I believe, what other states may fall within these rules that we've discussed, and what steps should be taken to preserve any potential refunds? Bill, you want to comment on that first?
Yeah, well, you know, with respect to the refund, I think the most important thing is to get the underlying facts, because whether the particular statute would be held constitutional or not is going to depend upon application as well as the naked statute. If you're in a state that has a tax, you want to decant out into some place that's clearer, and you want to see in the course of decanting what you can do to clean up your fact pattern. Whether you have a basis for a refund, it can have a lot to do with the underlying facts. The whole point why, before talking about practical pointers for drafting, I want to talk about ambiguity, that it just isn't so simple as to what could be deemed to be administration. So I think the real answer is that anyone who thinks that they have a situation in hand where there might be a basis for a refund, contact Terry, contact me. We'll be glad to take a look at it and see if there's a traction there. It's just not necessarily a bright line. Kaestner was a bright line. We were fortunate. And then there's Minnesota court did a great job.
Terry, anything to add?
No, David, I'm licensed in South Dakota, not in a number of other states, and I noticed that my malpractice carrier is signed in as one of the attendees. So,
Terry, we got 41 offices scattered about, so we're prepared to take on most bears around the country.
Well, and we also had that disclaimer at the beginning, so we're fine. We're covered. A question came in around conflicts of law, and Bill, you touched on that, and I'm going to paraphrase the question. This idea of nexus and when a state can impose its income tax laws can probably be analogous, I suppose, to the conversation around asset protection, right? So the idea is, yeah. And the question is, so if a state says you need a certain amount of touches to tax, can't the same argument be made, well, you also need a certain amount of touches for a state to be able to somehow say the asset protection doesn't apply out of South Dakota or Delaware or wherever? Yeah, I love you both to comment on that.
Well, restatement is pretty clear that generally a state should respect the choice of law by the settlor, except where the choice of law doesn't have the maximum amount of contacts with what's going on. All my real estate is sitting in Connecticut or New York, and I've titled it in directly into a South Dakota trust. Then the restatement says, take a look and see if you're violating any fundamental policy of the settler's domicile state. Well, in New York, that's easy. You can't have a self-settled spendthrift trust in New York. So I think that the real problem you get into is, and it's totally unanswered with respect to Fielding and Kaestner, what do you do when the settlor is a beneficiary of the trust and the settlor is domiciled in a state that does not have a domestic asset protection statute? Then you do hard thinking, and you want to. We'll go back to everything I said about maximizing the contacts with the state of the trust situs and minimizing the contacts so that you don't get thrown into that language in the restatement.
Excellent. Well, we are exactly at an hour. I want to thank you both very much for participating in this webinar with Bridgeford Trust Company. Clearly, this is a very important issue, and analysis and practical implications is what everybody's looking for at this point, and I think you both did an excellent job in doing that. I'd like to thank so many people from around the country and really even around the world that have signed into the webinar. I hope you think it was as helpful as I do. Our goal at Bridgeford is to be at the forefront of these issues, and having great minds and national figures like Bill and Terry participate is excellent. For more information about this issue and any other modern trust law issue, please feel free to go to our website. We endeavor to work very hard to provide educational information about all these modern trust law aspects and ideas which we touched upon today. I think that as you move forward, we're in a new trust paradigm. There's no question about it. We're in a whole new world, and jurisdiction is more important now than ever before. So again, Bill and Terry, thank you so much for participating.
Well, thank you for having us participate. This is a lot of fun for us preparing, and hopefully the audience enjoyed it. Thank you, David.
Absolutely.
Thanks, David.
Of course. And again, I mentioned we have 2 podcast interviews with both Terry and Bill, which are extremely interesting. I would encourage you, if you would like to hear more about, of course, South Dakota law and Bill's really trailblazing work in the tax planning space, please check that out on the website. So again, thank you all for joining us, and we'll hopefully be working with you all in the near future.
Thank you once again for joining us for this webinar recap produced by Bridgeford Trust Company. You can stay connected to us and learn more about all the insights we provide, including upcoming webinars, events, news, and our newly launched podcast series by visiting us at bridgefordtrust.com. Thanks again and have a great day.